2021 Mold 408 Supplementary Statement of Complainant Value Accused contended that supplementary statement of complainant could not be exhibited, but the trial court overruled the objection. Validity supplementary statement had got no sanctity in the eye of law. Value of supplementary statement or further statement was not more than a statement recorded under S.161 Cr.P.C In the present case. The trial court erred in law while exhibiting the supplementary statement purportedly made by complainant. Said supplementary statement of the complainant was nothing more than a statement recorded under S.161 Cr.P.C, which could neither be equated with first information report FIR nor could be construed as an extension thereof. Such statement could not be used for any purpose other than one provided in S.161 Cr.P.C Trial Court, while exhibiting the supplementary statement of the complainant, had committed an error. Therefore, the objection raised by the accused was sustainable, which was wrongly overruled by the trial court. Criminal revision petition was accepted, and the objection of the defense was sustained. 2021 Pearl J 504 S's 161 and 162 Examination of witnesses by police. Statement to police not to be signed. Use of such statement in evidence. Exhibition of supplementary statement in evidence. Scope. Petitioner assailed order passed by trial court whereby supplementary statement of complainant was allowed to be exhibited during his examination in chief. Validity station house officer was bound to reduce into writing information regarding any cognizable offense rendered by the informer, and there was no legal impediment for its exhibition during the trial once the crime report was lodged. Any information gathered by the complainant at subsequent stage and placed before the investigating officer was treated as his statement under S.161 Cr.P.C, which could be used by the defense for the purpose of contradiction as provided under S.162 Cr.P.C. Complainant was always at liberty to make statement before trial court regarding contents of such statement or application, as well as his other statements recorded under S.161 Cr.P.C, but there was no provision in the criminal law for independent exhibition of such statement. Trial court had committed material illegality while passing the impugned order, which was set aside, and the revision petition was allowed.